Welcome to this briefing on the recently completed Shoreline study by the League of Women. My name is Marty Gibbons. I am the Climate and Energy Issue Chair for the League of Women Voters in Washington. The League is known for careful study of important policy issues, and this is one of those studies. Through discussion and consensus at the local league level, these studies lead to positions the League takes. These positions are essential to the League and to our issue chairs as they evaluate state government policy and communicate with state government officials. This presentation is the opening of the consensus process. Next slide, Shelley. You may type your questions as you have them in chat during the presentation, and we will answer them at the end. Or you may raise your hand after the presentation to ask your question vocally. You can see how to raise your hand at the lower part of this slide, and you can open chat to see the questions being asked as we go. So we know who is here. Please ensure your name is correct under your picture and include your local league or city. Use the rename option to make that revision. It's the 3 dots in the box in the upper right-hand corner of your image. You have the option to remain anonymous if you choose. This briefing is being recorded. Please remain muted until the question period following the presentation. Now I am pleased to introduce Shelley Kniep, Chair of the Study Committee. Shelley.
Hello, everyone. I'm Shelley Kniep, and I chair this committee that we've been working on since January of 2020, and all through the pandemic. And now we're at a point to give it to everyone in the state league and to turn it over to local leagues. So today will be an overview of that. First, I want to talk about studies in general. It's been a long time since the state league has done a study. And now we have 2 or 3, but before the league takes a position on the issue, we must conduct a thorough and objective study, which has to be accurate, balanced, and credited. The study itself does not make recommendations. It will identify issues, and then it's up to league members to determine whether or not you want to take a position on those issues. We have a guide to effective studies on our website that walks you through the whole process. And from that guide, we learned that the study must be accurate, balanced, and credited, showing your sources, and we have done that as far as we think. And then it goes to consensus, this consensus process. And Mary Coltrane, who's the program director, will talk a little bit about this at the end. But consensus does not mean unanimity, if I could say that. And it's not just a majority. It's more an overall sense of the group as expressed through the exchange of ideas and opinions. So once you review the study, local leagues should set up a process to come to agreement on the consensus questions. So this is just, this slide is just a recap of that. And if consensus is reached, and there's no guarantee that it will be, but the position statements are created on the studied topics. And then the position statements will form the basis for any advocacy. And they're good to have, even if nothing is happening at the legislature. You never know when a bill's going to come up and surprise us. So now I'm going to get into this study. it was first proposed at the 2019 convention, and the second bullet here is what the proposal was. This, and it was, as you can see, it's fairly broad. We found that it's just overwhelming to gather data on current shoreline conditions, projections, and issues, and you'll see why. And so we decided to narrow it down to looking at the Shoreline Management Act. And it has been in effect for 50 years and has not been amended much. And so that's what we did. We formed a committee. All the members of the committee are here. Ann Agard, Betsy Cooper, Phyllis Farrell, Marty Gibbons, who you've heard from, myself, and Ann Ben Swearingen. So the first month or so we took scoping, but we studied the law and its implementation, and we identified what we thought were important questions. And we decided to interview a broad range of stakeholders. And we also met with Department of Ecology managers for the Shoreline program. We met with them 3 or 4 times, long meetings. And then from 2021 to 2022, we wrote the study that includes background information, identifying the issues. And this year we've been focused on the consensus process. Everything had to go to the state board for approval. We got the study to them in March, after it had been through a technical review and a reading committee. So it's quite the process. And then we've been working on consensus questions, which have been approved by the board, and now it's all going to the local leagues. So the Shoreline Management Act, it was enacted through a citizens initiative to the legislature in 1971. And the study includes the history of that. The president of the state league was also the president of the Washington Environmental Council that sponsored this initiative. And because it was an initiative to the legislature had 3 options: adopt it, reject it, or modify it. And the legislature chose to modify it. It came back to the voters the following November, and the modified version was adopted as the Shoreline Management Act at RCW Chapter 9058. Then we have administrative guidelines. They're called guidelines, but they're really regulations adopted by ecology in the Washington Administrative Code. And the Shoreline Management Act is an environmental protection / development regulation applicable to shorelines at not just the ocean, streams, river, lakes, and associated wetlands. And it's unusual as a land use type or ordinance or regulation in that it's administered by both the state and the local jurisdictions. So counties and cities adopt shoreline master programs, and they do the permitting and develop a shoreline master plan and develop their regulations. But ecology must approve those plans, and ecology must also approve certain types of permits, such as conditional use permits and variances. So here's a map of all the shorelines that are regulated in Washington state. The green lines are saltwater shorelines. The blue lines are freshwater shorelines. And you can see, although there's a lot in Western Washington, there's also a lot of shorelines in Eastern Washington. So every county has some kind of regulated shoreline in it. Not every city does, but most of them do. So almost every jurisdiction has a shoreline master program. Okay, so when it was adopted in 1971, the legislature set out findings and policy goals. And there are three major policy goals. One is protecting against adverse effects to health and the environment, while also planning and fostering for reasonable and appropriate uses. And the other one is promoting public access to shorelines. And we'll get into that a little more, which is different for a regular land use or regulation. So the Shoreline Management Act regulates the uses and development of shorelines and 200 feet landward of the ordinary high water mark. And determining the ordinary high water mark is very complicated. Ecology has a manual for doing that. It's about 250 pages long. But generally it's the mark made by ordinary high water. So anything that's done 200 feet landward of that generally requires some kind of compliance with the Shoreline Management Act. As I mentioned before, it preserves public access, and this is based on the public trust doctrine. The public trust doctrine is a legal doctrine that goes back to Roman times, and it is administered by courts. It's not necessarily codified into a law, but it is the tenet that there are certain things that the public has an absolute right to, and private ownership doesn't necessarily count. In Washington, the courts have interpreted it to be generally the right of navigation. And say someone owns a private tideland. When the water's in, the public has a right to be on that water over the tideline. When the water's out, the private property owner can bar people from it. But that's part of the public trust doctrine. And we go into that in pretty good detail in the study. So there are challenges unique to shoreline regulation. They are, as is stated in the Act, among the most fragile and valuable of our natural resources. And as I mentioned, the Act itself is complex, both in the subject and the administration of it. And shorelines are complex ecosystems, all by themselves, with tides and various habitats and various levels of salt water. And even more so if you add development on top of that to change things. So in our study, we decided to try to interview people who had some kind of connection to the SMA. Either they were regulated by it or they regulated it. So we tried to get as broad of a range as we could. We, of course, talked to all the regulators. We had representatives from the Department of Ecology, county planners, one county commissioner. We talked to people from cities. We talked to a former member of the Shoreline Hearings Board. We talked to people from Department of Fish and Wildlife and from Puget Sound Partnership. We talked to an academic person who was well-versed in the public trust doctrine. We talked to a couple of environmental groups, FutureWise and the Center for Food Safety, both of who have brought cases on litigation under the Shoreline Management Act. We talked to people in the industry, the shellfish industry, some developers, and a company that builds bulkheads. We talked to a property rights advocate from the Pacific Legal Foundation, and they do a lot of litigation on property rights. We talked to the manager of the Port District, and we talked to 2 tribal representatives. We tried to get volunteers more from the eastern part of the state, and just were out of luck. We tried to get a realtor, and we tried to get someone from the Farm Bureau, and they just said they didn't have time. So we tried. We asked each individual the same 10 questions. And these are a shortened version of the questions, but how has the Act served us over the past 50 years? Has it successfully protected our shorelines and resources? And what they thought about the partnership between the state and local governments and how that was working. And is it as applicable today as it was 50 years ago? There's been a lot that's happened in 50 years, including a lot of other types of environmental regulations. What would provide in the Act better protection while still allowing reasonable shoreline use? And what aspects of the implementation did they think should be changed? We asked what the roadblocks are to effectiveness, got similar answers from everybody on that one. And is there adequate public access to our shorelines? And what about the next 50 years? Is it still equipped to deal with the next 50 years? Does it need to be changed in any way? And are there any provisions of the Act that are unnecessary? So we compiled the responses. We did some complicated spreadsheets, looking for recurrent issues and themes. We also did our own research. We reviewed a lot of the hearing board decisions and court decisions. At one point, we had an intern at the Evergreen State College who did a literature search for us, and she found some interesting studies. And we identified from that compilation 14 issues. And those are what we found were recurrent from our answers and our studies. One is that shoreline master programs are required to go through periodic reviews every 8 years. They have to go through an update. They were supposed to be done with this comprehensive update in 2014. And several of counties and jurisdictions still have not done that. One thing I left out of the history was the guidelines. We mentioned the WACs. In 2003, they were extensively updated to include a new provision that shoreline master programs have to ensure no net loss of ecological functions. And that is presumed once the update is done and approved by ecology. And so those jurisdictions that have not done that update are not necessarily assuring that. But during the periodic reviews, it is really limited. Every 8 years, they go back and look to see if there's been a change in the law or what else has happened. They don't have to go back and redo the basis of their plan, which includes an inventory characterization and a cumulative impacts analysis. So they're basically just looking for changes in the law. There were quite a few people who thought that updates should include more than that. And there's been some litigation on that, but hasn't been successful. We heard a lot about exemptions. As in many laws, there's a million exemptions. That's a little bit hyperbole, but there are plenty, including single family homes, docks, and the exemptions vary on what is required. Even though they're exempt from the permit, the substantial development permit, they are not exempt necessarily from complying with the Shoreline Master Plan or Act. But who's looking at that? And why are single family residences exempt? And so there was a lot of questions about that, that was too broad and allowed too much development. And maybe so, maybe not. We heard from a few people about the 3 legislative goals: protecting the environment, fostering uses, planning, and preferred uses, and access, and whether or not those should be equally weighted or treated when evaluating a permit or a plan. A few people said we think that the policy of protecting the environment should have more weight than the other two being development and preferred uses and access. You can read the statute to say that, but it's not explicit. And in fact, the ecology guidelines say that local jurisdictions have discretion on balancing. So that one seems to be confusing to a lot of people. And I mentioned that no net loss. There are no standards to measure that, and it's not measured ever again, as far as we know, once a plan is approved. So when ecology approves the plan, it's assumed to meet the no net loss standard, but there's no going back and checking to see if it has been met. Habitat restoration is a big one. In order to achieve no net loss, you pretty much have to have restoration. We heard a little bit about public involvement through the planning process and the permitting process. We heard some about industrial aquaculture, and this is a distinction. There's a preference for aquaculture, a preference for water dependent uses, which aquaculture is. But we've seen a shift in the last 10 or 20 years from small scale aquaculture farms, shellfish farms, to large gooey duck farms that really seem to have more of an impact. Monitoring and adaptive management, both of those are required under the act, but how many jurisdictions are actually doing it and what do they do with the results of their monitoring? Public access, we generally heard that public access was good, but there were concerns about with an increasing population, there will be less of it. Fewer access sites for more people. Climate change. There is no requirement either in the SMA or in the WACs for a jurisdiction to consider climate change. It's entirely voluntary. Grays Harbor County completed its first comprehensive review while we were in the midst of this study. It was challenged because it did not address climate change, and the Shorelines Hearing Board said it did not have to consider climate change. There are some jurisdictions that are doing that, especially for sea level rise. There are projections for sea level rise, but it's entirely voluntary. We heard some about ecology oversight and how much oversight is adequate for local programs, whether they should be checking on permits, other types of permits periodically. Ecology does do a lot of training for local governments, but should that be mandatory? And we've talked about training. Enforcement. We found a study out of King County that looked at all the modifications to a certain area of shorelines, and 42% of those were illegal. And what typically happens is after the fact, they get a permit. So sometimes they're made to do some mitigation, but enforcing, we may need strengthening in some jurisdictions. And training not just of staff, but of the elected officials who often hear appeals, and incentives for restoration or soft bulkheads, more incentives, because it's expensive. We looked at one case where a hard bulkhead was replaced by a soft bulkhead, which is better for the environment, but it still costs, even with the grant, it still costs the property owners $30,000. So with that, you can find the study on our website. And this slide shows you where to find it if you haven't already. And we will be posting this PowerPoint and posting a recording of this presentation. And the next steps are, as we've talked about a little bit before, each local league will review the study and turn in a consensus one form to the state. We'll compile those responses and develop a league position, which we're hoping to do at the 2023 convention. And now I'm going to turn it over to Mary Coltrane, who will talk a little, the program director, who will talk a little bit more about the consensus process. Mary?
Thank you, Shelley. Is there a slide that is prior to this one that talks about the discussion leader rather than the recorded? Yes, thank you. Thank you so much. Well, thank you to Shelley and to all this committee for this amazing work that has been done over this last couple of years or so. And now that all this great work has been done, what we want to do in the League of Women Voters is get to consensus. So we don't want to have conversations and discussions that end with nothing happening. We want them to end with some points of discussion, of consensus, so that we can draft a position. And so I wanted to ask Shelley if I could just take a couple of minutes to put this in front of you all, because I'm assuming you will all be part of the discussion process. Some of you may be organizing the meeting for your league. Some of you may plan to be discussion leaders, or you may be interested in being a discussion leader. And so I'd like to encourage everybody, whether you are involved in any of those roles, if you are at the discussion where the consensus is taking place, you do have a job to help us get to consensus, and you can accomplish that job the easiest if you understand a little bit about what the discussion leader is trying to do. And so that's why I asked Shelley if I could put this in front of you. The discussion leader is going to be a traffic cop, so they want to have an open, relaxed atmosphere that encourages everybody to talk and to set the tone for the meeting so that it's a relaxed meeting, so people feel comfortable, so that they're not feeling shy. Many league members are shy, others are not, and we want to hear from both. So the discussion leader needs to be on the alert for cues from the group so that they can know, okay, we've covered that part of the topic, it is time to move on. One of the ways they can do that is by restating the consensus points so that, yes, this is what we agreed to, so let's move on. So you have some definite points in the discussion where you can say, yes, this is done, let's move on. And the discussion leader is charged with making that happen. Could you go to the next slide, please? Next, no, the recorder slide. Go back to the recorder slide. Back one. So the recorder is a key person in helping get to consensus and helps the discussion leader do this job. The recorder will get the consensus form and be charged with writing up the answers to what people are saying. They will summarize the progress as it's being made, and they can ask for clues as to what they should write down and get agreement that the consensus point is correct. So the discussion leader might turn to the recorder and say, could you please summarize for us where we're at now? Those kinds of things. You as attendees at these consensus meetings can help with that. The discussion leader does not have to be the only one who asks for hearing from the recorder as to where we are right now. You can say too, oh, would you please, recorder person, would you please tell us what you've got? And the recorder person can tell you. And that kind of helps the discussion from wandering too far afield. So in order to make sure that we all have the tools we need, and the state board wants to be as helpful as possible in this process, the program work group is, which is a subcommittee of the board, is organizing some discussion leader meeting plan trainings. And so if you are a person who is pulling these meetings together, or you're a discussion leader who would like to know more about it, if you would shoot me an email, I will invite you to a meeting where we will discuss all this in more detail and have these tools available for future use as well. So that's it, Shelley. I'll put my name and email in the chat so people can shoot me an email. Planning a meeting later this week, maybe early the following week. And if you can't make it to any of the meetings that I'm putting together, no worries. I could talk to you by phone or by Zoom or whatever is convenient, so that you have the tools to get the consensus occurring so we can make use of this good work.
All right. With that, we'll take questions, and our committee members, Ann Ben Swearingen and Phyllis Farrell, are going to monitor the chat. And do you have any questions for us yet?
Yeah, we have 3 questions so far, but let's start off with a question about, does this SMA apply to federal lands and tribal lands?
For tribal lands, if it's reservation land or in trust, probably not, due to tribal sovereignty. Federal lands are a little more complicated because there's a federal law called the Coastal Zone Management Act, which incidentally was enacted after our Shoreline Management Act. And our Shoreline Management Act covers part of the requirements for a CZMP, Coastal Zone Management Plan. And that does apply to federal lands. So hope that's helpful.
Okay, thank you. We also had a question about no net loss, when and how it's determined regarding, and my understanding from the question was regarding a specific project rather than overall for the county.
Well, it's kind of not determined for a specific project, and Ann Agard worked a lot on the 2003 guidelines, so she might want to chime in on this. But no net loss is presumed once ecology approves the local government's plan. So if a permit is according to plan, the plan, it's presumed, and there's no evaluation done of that. So say the plan allows single family residences in this area, and if they meet all the regulations in that plan, then that is presumed to meet no net loss. On variances and cumulative or conditional use permits, there is a little more analysis that has to go into it. And it's really, it's not measured again once the plan is approved, even though there may be illegal development that might have affected the whole ecosystem. And that's the issue that we've raised about how to measure it and how to and whether it should be reviewed again during an update or so. And did you want to add anything to that?
Yeah, thank you, Shelley. Yeah, the guidelines do say that it's no net loss on a permit by permit basis, but you are also absolute. So how you interpret that is, I think, still not yet totally clear, but you are absolutely correct that once ecology approves the Shoreline Master Program, they have essentially said this will meet the no net loss standard. But there are two issues, as you correctly pointed out, that need to be emphasized. One is that currently under the periodic reviews, there is no requirement that you really go back and look at the whether there has been no net loss. So that's why this is one of the questions that we're asking and looking at and discussed with our experts when we wrote the study. And the other part of that is that the cumulative impact analysis, which is not formally part of the actual adopted Shoreline Master Program for a local jurisdiction, was done many times before the Shoreline Master Program was even adopted. At the end, by the end, it was done early on in the process. And so those cumulative impact analyses, which were the basis for determining whether or not there was no net loss, are basically out of date. And so, but there is no requirement to update them. And my understanding is that when ecology looks at amendments to a Shoreline Master Program, their basis for that is a cumulative impact analysis. And so there's some disconnect as to how this no net loss is to be determined. So thank you for pointing that out. And I think you'll see that in our study.
And another comment that Ann mentioned earlier was that the Grace Harbor decision regarding climate change has been appealed by FutureWise. So, Ann, do you have any clue as to when we might expect that case to be decided?
Do,
You're
I don't
muted.
know.
Yeah.
Okay. And then another question we had is, what role might a non-league member who's knowledgeable about the subject play in a local league consensus project? That's probably a question for Mary.
Yeah. You're on mute.
Could you repeat the question for me, Phyllis?
Good. What role might a non-league member who is knowledgeable about the subject play in a local league consensus process?
The consensus process is for members only, so they would not be able to participate in the consensus. They are certainly welcome to join, so they
Yeah.
could become a member. That would be great.
That was my answer too.
Yeah.
Join the
sounds-
league.
All right. Okay, another question from Martha Burke in Kitsap County. Is the legislature likely to make changes to the SMA in the next session? And if so, what kind of changes are anticipated?
Well, we've seen some proposed changes in the last couple of legislatures. One requiring some analysis of climate change that didn't pass. And we've seen some proposals to change the no net loss standard to net gain. I don't know if those are coming back, or advocacy team may know more about that. But the fact that it hasn't been amended much in 50 years compared to the Growth Management Act is somewhat telling. But and that's another complicated part of this law, is its overlap with the Growth Management Act, and that's in our study as well. But there may be some changes along those lines.
And if I can also just add, I think the other component is there could be ways to improve the implementation of this law, and through changes that ecology would be required to make in their regulations. So it isn't necessarily just a change in the actual act that could implement and improve some of these conditions. So I think that's the other reason that looking at possible amendments or augmentation to our position so that we can advocate for some of those implementation changes is also something that's important to consider.
Yeah, and there was also some changes to fish and wildlife regulations. I think in 2021, and you may remember about in evaluating bulkhead replacement and mitigation for that. But
And I believe also there were some efforts in the last legislative session to look at riparian buffers and mapping and related to tree heights that might apply as well. And Ann Murphy had asked a question also, and Ann, I'm not sure if this was answered here with how net ecological gain would fit into current legislative proposal. Is your question answered, Ann?
You mean me?
No,
Annie?
Ann
No,
Murphy.
me,
Oh,
Ann Murphy in Spokane. I think it was kind of, but what has legislation been on the net ecological gain? I guess we could go a little bit further on that.
there has been legislation to change the no net loss standard to a net gain standard that has not passed. There is currently a study being done by the
By
state,
whom?
by the state
Okay.
on net gain, and it's to be, the last we heard was it was to be issued towards the end of this year. And I'm blanking on the name of the agency that's doing it.
And are there same issues there in terms of measurement and all that kind of stuff with the no let loss one?
I would think so.
Yeah.
ENR was the agency.
No, it was, hold on a second.
Fish and Wildlife, sorry.
Fish and Wildlife, and it's been the Washington State Academy of Science is who's doing the study for Fish and Wildlife.
Okay, thanks.
Okay, another question, this would be for probably Mary, is the timeline for getting consensus to the local level?
The deadline from the local league boards is January 16th. And it is hoped that the committee will be able to use information to draft a consensus or a position statement that the board can review and adopt probably in February or March, and then it will be available for use. And finally, it will be affirmed by the membership as part of the current program at our convention in May.
Thank you. And another question from Joan Smith in Snohomish. Did the committee examine the process where the permit fees pay the salaries of those who work in planning and development? This can lead to exemptions and a softness in interpretation of the rules. Shelley.
You know, we talked about that. It's alluded to in our study. We couldn't really quantify it. Several of us have worked with local governments and have seen that can be an issue. You know, some of the planners consider their stakeholders the developers and the people applying for permits and not the general public. But we really couldn't quantify it very well. There is that pressure, and it's, I think, on all government employees at all levels, there's a bit of a political pressure. But at the same time, we also noted that appeal fees of permits have gone through the roof all over the state, and that has probably discouraged people from appealing permits, because some of them are $5,000 just to file an appeal of a local permit. We really had a hard time trying to figure out how to quantify that, and it didn't come up that much with our respondents, but it did once or twice. But that's could be another study on permit fees and appeal fees and whether or not they should be capped and how that all works.
Shelley and Phyllis, Ann Agard has her hand up again.
Oh, and
Yeah, I was going to just add a couple of things on the climate change issue and the no net loss issue. You're right. I believe the funding to WDFW for looking at the the net gain issue is due to finalize this year, and we're looking forward to seeing how that would play out. And part of that has to do with this issue of using best available science and the site specific tree height as the measure for the riparian setback. So that gets to be another really complicated issue. But what I do want to point out is what Shelley said about this integration between GMA and SMA, which is the SMA policies are part of the Growth Management Act, but there is a lot of crossover. And one of the important things that a number of league members have been following kind of on an unofficial way has been the Department of Ecology's development of, this is not the official guidelines for SMA, but guidelines to local governments for critical areas ordinance. But there is a huge crossover between the critical areas ordinances in a Growth Management Act and the critical areas within the shorelines. Some are separate, but some are the same. And I've been following this very carefully, and the Department of Ecology received many comments about including climate change in their critical areas ordinances. And their final draft, and this is an informal guidelines to local governments, not official ones, but they still carry a lot of weight. They are revising these guidelines, and they were due out a couple of weeks ago to include some climate change in their critical areas ordinance. So,
And just to clarify, it's Department of Commerce.
no,
Is that
no, this
their
is
guidelines?
no. There are two things. You're correct, Shelley. There are the Department of Commerce guidelines, and yes, we have been following those too. Just an informal group of league members have been following those, but those are now being finalized. And those are guidelines for the GMA updates.
Right.
And the important thing of that, it's a strange situation. They don't require local governments to follow the guidelines, but if a Growth Management Act comprehensive plan is appealed to the Growth Planning Hearing Board, then the board looks at those guidelines as during the appeal to see if the local government has complied with the guidelines. So they don't really kick in unless there is an appeal.
Yeah.
So it's a bit of a difficult situation, but they still carry some weight, and it's worth watching. So there is a lot of pressure to include climate change in that. So, okay.
We've got another question from Snohomish County. The question about the SMA's role on tribal lands, such as tribal trust lands, is an important one, since some tribes, such as the Still-Guamish tribe, have purchased and turned into trust land over 1,000 acres of land in Snohomish County, some of which would fall under the SMA if it wasn't tribal trust land.
I think that's more of a comment than a question. And it deals with the sovereignty of the tribe. And once it's turned into trust land, it becomes sovereign land. So unless there's a follow-up to that.
Okay. Ann Murphy had a question. Typically for consensus discussion meetings, there's been a resource person present. Will members of the committee be available to be at local meetings to fill that role?
Yeah, probably through Zoom if possible. And we are going to try to coordinate and be available to all the local leagues. There are 6 of us, so hopefully we can do that.
And then, go ahead.
Just note, should they contact Shelley or should they contact Marty? So in order to organize this, I think it's important that they know who they should contact. Is it best to go to Marty or?
Marty's leaving the country pretty soon, so I will put my email address in the chat. And then I'll work with the other members of the committee to get us fully staffed at these. Is that okay with you, Marty?
Yes, that's the right way to do it. Shelley, if you can.
All right, the next question is from Stephanie Cordsey, Clallam County. Are the official 9 consensus questions and additional clarification questions included in the report itself?
No, they are in a separate document. And Mary Coltrane can help us with that. They're on the web, where the study is also under programs, for members programs. And it's a JOT form. As we mentioned, each league submits one form to the state league. And I think Mary has it available in a PDF for people to use, but only one form should be submitted on behalf of the league. And if it's submitted in the JOT form, format, that will make things easier for us to compile. Mary, did you have anything to add?
Well, I don't have it available in PDF form for each individual league because each league needs to select their name and then convert it to a PDF. So just to clarify that, but you can transform it into a PDF and then distribute it as is needed amongst your members. And we can talk about that at the meeting organizers training later this week. And so if you want more information on that, shoot me an email and I'll make sure you get an invite to that meeting.
Well, and that goes along with Joan Smith's question in Snohomish. Our league has discussed a question of taking 3 of the questions at a time. This may mean different people discussing different questions. Would this be a problem overall?
I think I think you need to, I could see breaking out. So if you have all of these people together, you can break them out into small discussion groups, or you can break them out using Zoom. But to have one group look at the first 3 questions and another group look at the second 3 questions, I think you would lose the totality of information that you would want to be considering, kind of going back and forth. Shelley, do you want to add to that?
Not really. I think you're probably the best person to add to that or to answer that. But my understanding was that leagues could, figure out any process they wanted. But
How about you, Ann Murphy? Do you have any comments on that?
Well, Mary, I would tend to agree with where you're going on that in terms of the totality of the discussion, but 9 questions does make it kind of prohibitive, because I mean, if you just do a quick 10 minutes per question because you've got both a discussion and a consensus tied together, then you're quickly at an hour-and-a-half meeting already and didn't make any kind of presentation or anything. So there's just a certain amount of creativity, I guess.
Yeah, this is true.
Partly because this whole process was set up when leagues met in smaller units, and so maybe 10 people were discussing, and then each of within the local league they had to compile those things. So I mean, it's all different. It's not the way we used to do it, which doesn't mean that's a good or bad thing, but moving forward, it's getting creative in your process.
And this is something we could discuss at the a meeting organizing training, just to make sure that, I think one of the key underlying principles we want to emphasize is that everybody is invited to participate in the consensus process. That's the key there. And how, as you were just saying, Ann, how we get there, we need to be creative about it. I agree.
Well, and we've now thrown Zoom into the mix and having to deal with, the whole differences there. So anyway, it'll be fun.
Yeah.
Phyllis has something to say.
Yeah, a suggestion that might work that I often used when I was teaching was to break into the 3 subgroups and have them report back then to the entire group, this is what we found on question number 4. But then the whole group then still did the consensus, but it facilitated the conversation is to, have a small group work first, but then report back and have the consensus with the large group.
That's interesting. Very interesting. Yeah, you would be able to get at the totality issue that way. And then
Right.
everybody is buying into the consensus for everybody who's present at the consensus meeting is buying into the consensus process and the consensus conclusions. Yeah, that's creative. I like that.
So we had some other comments in the chat that I think might have been overlooked, and things were coming fast. One was about the Olympic Climate Action Group that's been involved in the Clallam County SMP update. I think this is more of a comment that they, the county did not want to include anything about climate change, and that he believes that by not doing this could put the county in jeopardy of some legal action if climate change resulted in a life or property loss. Yep. Probably, yes. I mean, we think of the Oso landslide, and Snohomish County was sued under that one. And I think part of that suit had to do with critical areas, but having been a county attorney myself, I know that counties get pulled into lawsuits on everything from car accidents to major flooding. So that wouldn't be something out of the realm. And then from, I think, Mason County, Francesca talked about she's heard there's not enough staffing or salaries to oversee implementation, and any thoughts on how that can be corrected? And that came up in our question a lot, our question on roadblocks to effective implementation, and funding, and retaining staff is really hard for local governments and for ecology, but more for local governments. They get a lot more turnover for administering a complex law like this. And then Stacy Valenzuela asked about determinations of non-significance and how they affect shoreline development. That's under the State Environmental Policy Act. Whenever a permit's involved, they have to do an analysis, and there's a lot of exemptions to that as well. And it's up to the jurisdiction. So there are 3, they can either require an EIS, which is a determination of significance, issue a determination of non-significance, which means the project goes forward, or issue a mitigated determination of non-significance, which applies conditions. And so that's on a project by project level, and I don't have any strong feelings on that. Phyllis?
Yes, I know in a situation here in Thurston County, there was a determination of non-significance, but you had to, in order to appeal that, you had to have standing, which meant that you had to have had either commented or made written comments or submitted written comments or testimony. And then if you did have standing, then you had to then come up with the money for the appeal. And it was in the thousands of dollars range. And, you know, an individual or a small NGO you know, we just backed off of it because none of us had the money and wanted to try to take that on. So to me, that's a problem.
I see one more question from Karen Crowley about whether the questions build on each other. Is the order intentional? Yes and no. We did try to rank them so that the first importance in our minds are of each issue. Knowing there were a lot. We originally had 10, we cut it back to 9. But so I think we would like the local leagues to answer all the questions, but if there are time constraints, then 8 out of 9, 7 out of 9 would probably be okay. Mary?
I just wanted to add, to emphasize that the discussion questions are optional. So they're just to kind of get your juices going. You don't have to dwell on the discussion questions.
Yeah. Wow.
Maybe one other just comment continuing on to Shelley's response to that last question about the consensus questions. Consensus question 8, while it's down on the list, is kind of a meaty one. It's about those, the actual question about preference of uses, and that I would hope people do still try to read about that and think about it, because that whole question of whether the way that ecology and everyone looked at what were appropriate uses to be preferred and allowed in the shoreline way back 50 years ago versus today, it kind of is, it does underpin some of these other questions. So we do hope you at least look at all those questions, even if you don't come, if there isn't an opportunity to have the conversation and come to consensus on for an answer on each.
Is there anybody who wants to ask a question verbally? Just raise your hand. Deb from Pullman. You're on mute.
Okay, as some of you know, by profession, I am an archaeologist. So I'm wondering where the SMA stacks up against the cultural resources protections in the state and the federal.
Well,
What takes precedent?
you know, there are, you know, I'm sure, and I didn't know that about you. Very
Oh,
interesting.
I'm sorry.
There are separate statutes on archaeology and on the federal and state level. And I have seen projects halted if archaeological items have been found, especially on shorelines with middens. And
Yes.
I think I wouldn't say there's something that takes precedent, but it certainly can change or halt a project if there's archaeological.
Oh yeah, I know that, especially the middens frequently contain burials, so.
Right. Yeah, I had a situation on Bainbridge Island where somebody was replacing their septic system and found that it was a burial ground.
Mhm.
And that was a real mess. So,
Oh yeah, I've had one of those situations myself.
yeah.
I mean, I was the person who found the human remains, so yeah.
Ann Murphy.
Phyllis mentioned and you did earlier, the high cost of appeals in the $5,000 range. What's the cost for the original permit? Ballpark.
Well, that varies too.
Right.
Some years ago, during the last recession, at least in my experience, but before that, counties were moving their planning and permitting departments to revenue funds, where they were trying to gather all their revenue through permit fees. And there was a class action suit brought by developers against King County for that. And there's a series of decisions by Judge Alan Dorfer, it was brought in Snohomish County, on how these permit fees can be structured. And the permit fees for appeals are often higher because lawyers are involved. The county has to get their county lawyer involved. And as long as they can justify it, they typically, there is no limit on those. That might be something the league wants to analyze, because I think personally, we've lost grassroots, right to appeal certain land use decisions, because they're in Lacey, I think it's about $5,000. At least it was reported in the paper, to appeal a permit. But I don't think the cost of the permit has anything to do with the appeal cost. And it could be much lower.
Well, it's sort of like the cost of filing an initiative. If it's such a low cost to the person doing the permit, maybe if those were raised, some things might not be
Right.
requested to be permitted in the first place.
Right. Well, on the other hand, if you're going to appeal something to Growth Management Hearings Board, there's, at least since I retired, there's no appeal, there's no fee at all.
Well, it's all over the board then.
Right,
Okay.
right.
Righty, the next question is from Bob Vreeland, and it's a statement, I think. Assuming the LWV proposes legislation requiring potential climate change issues be considered in approving and mitigating proposed shoreline development, I think you can count on OCA support for such legislation. No, I think that refers to
And Marty had to leave, but maybe somebody else from the advocacy team can speak up whether or not we generally propose legislation. I know we support or oppose. Ann Murphy?
Sorry, I keep talking. I'm sorry about that, Shelley. Yeah, but we want to be really careful that we're not talking about advocacy as part of a study process. So, and that's one of the reasons the actual questions and the promote to consensus are not in the actual document, that they are kept separate, because Ed Fund is used for printing that document, but not for going through the consensus process. But yeah, we wouldn't be talking about this during the study process, and it would just come up after the fact. But yes, League has been involved. I mean, we talked about it, the GMA, and then the original SMA, League was involved in it. So very much so.
Okay, I think maybe we're done in record time.
I guess, yeah, I would just like to follow up on Betsy's comment on question number 8 about balancing of priorities. And when considering that question, just look at, how much of our SMA or local SMP work is for preferred uses, how much is protecting public access, and how much is protecting the environment. I think it may find that it's weighted and not balanced.
No advocacy. Okay, I don't know if we've
Shelley, now that is Peggy here.
Okay,
Hi, now that everyone is, not everyone, now that people are going, I will admit that I asked a question and then I had to take a telephone call. So I didn't hear the answer.
what,
Non-member involvement.
oh, we said to join. Yeah, the consensus process is limited to members.
Okay,
Um,
so members should,
welcome everyone to join.
but members can show non-members the study and ask.
yeah.
Oh, yeah.
Yeah. Yeah, the study's public on our website, and we distributed it to everyone we interviewed in the ecology people, so,
Okay, great.
and Murphy.
I would think, Peggy, and maybe, but Mary, maybe you might think differently, that a local committee that's planning the meeting, if they want some help from this person, I mean, that, I can see that being of value to your local committee, but not trying to sway your membership in their consensus process.
I agree, Ann, and I think the key word you've got there, the key point is that this person is not trying to sway. So even the committee members who are acting as resource people will be there as subject matter experts, but not trying to sway the discussion one way or another, but to shed light on some of these really, nuanced points and that are important to understand. And that's the proper role of the subject matter expert, that our committee members, that's their role. And if you have somebody who is coming to a meeting to help you plan this, and you want to draw on their expertise, that would be fine. But the discussion itself, that it will be the job of the discussion leader, and she will appreciate help from all members to keep the discussion balanced and to make sure that everybody has an opportunity to present their own views, and that the discussion is not taken over by an expert who understands more, blah, blah, blah. That happens. And so we want to guard against that. Yeah.
Exactly.
We just got a question about where to find things, and I am the study questions. I'm putting the link in chat.
Didn't you have a slide with links on it?
I did, and I can pull that up too if we want.
I think the question in the chat is about where the consensus questions are.
Right.
Yeah, that's what she's,
Yeah. okay.
Unfortunately, it didn't. Let me pull up that slide.
But I'll just mention while she pulls that up, you could go to the 4-member site. You have to log on as a member and then scroll down to program and work, and then look over for the shoreline study update. And then down at the bottom, you will find the questions, the consensus form.
Yeah, and we're gonna put this PowerPoint on the web too. So this link here is for the where you can find both the study and the consensus question. This link just has the study. Let me do this. See if I can do it this way and have it be a link in the chat. There, now it's a link.
Okay, well, I think.
So it's in the chat.
Okay.
And then the one slide we didn't get to is there are other resources, and one of them being the Guide to Effective Studies, which I think was written by Ann Murphy. So it's right that she's asked.
I was only the lead. I was just the lead.
Okay.
I didn't do all the work.
And here's our study. The Shoreline Management Act at washington.gov, you can find that. Ecology handbooks are pretty helpful. they're not the wax, so they're easier to read and have pictures. So, and this will be on the web. And as for including non-members, it occurred to me while you were talking about that, that some members might want to call their local jurisdiction and find out what their local jurisdiction does on a certain subject. I wouldn't, ask for your shoreline planner.
Oh, that's a great idea, Shelley. You could have a general meeting, and invite people to a general meeting to hear specifically about what's happening in your community, which would really augment all of this and make it more real in your own lives. I think that's a super idea.
Yes, yes.
And does everybody know how to save the chat if they want to get back to it later? If you open up your chat, click on chat, at the bottom, there's a little box where you type messages, but there's 3 little dots on the upper right-hand corner, and you can hit save chat. And then you have to find it on your computer because it's somewhere in there. But what I usually do is just pull up the file and search for chat. Sometimes Zoom will create its own folder and it'll be there, but depends on your computer. Okay, if there's nothing else, last chance.
Okay.
Well, thank you everybody for coming and attending and participating. We really appreciate it. It's your turn to take the baton now, so.
Thank
we will
you.
Rest.
Thank you, Shelley and committee.
All right, bye, everyone.
Bye.